information's coming in literally sometimes every few hours, at least every few days. And so we wanted to give you that update. And then we just want to talk through some of the kinds of things we're seeing businesses struggle with and invite your questions. So this can be more of a dialogue than a presentation. Hopefully that'll give you an opportunity to get some of your questions answered. So I'm Otto Schill. I've been around the chamber for a long time, and been at Jennings Strouss for about the past 4 years. Chris and John, you want to introduce yourselves?
Go ahead, Chris.
Absolutely. My name is Chris Mason. I've obviously participated in the presentation last week. I'm also an attorney with Jennings Strouss, one of the partners there. Been practicing labor and employment law for about 20 years now.
And I'm John Belitis. I chair the Labor and Employment Department at Jennings. I practice with Chris and Otto, and I've been in this field for about 35 years now. So I'm happy to be with you guys. Sorry I missed the first opportunity, technical difficulties.
And I should say I'm a member of the Tax, Estate Planning, Employee Benefits Department, and so I cross over with the Labor and Employment folks, and that's why you've got this collection of people on the phone. So let me give you just a brief overview. Last Friday, President Trump signed the CARES Act, and the first thing that happened after it became clear that the virus was going to be a bigger problem is that Congress passed the Families First Act, implementing paid sick leave and limited family medical leave on a federal level, and Chris will talk a little bit about that. I'll go over just briefly what's the major pieces of the CARES Act, because both of these pieces of legislation provide a variety of opportunities for companies to deal with their workforces. The overall goal that the congressional legislation or delegation has mentioned is that they want to keep employees connected with their employers, so when it's time to go back to work and get business back up and running, people aren't running around looking for jobs. They just step back into where they've been. And then John's going to lead us through some scenarios, and we'll talk about, like I say, real life discussions that we've been having all week long for the last few weeks. So with respect to the CARES Act, there are a couple of basic things that the Act has done. First of all, there are a series of loans that employers can consider. Perhaps the most talked about right now is the Paycheck Protection Loan, which is a forgivable loan that small employers can get. If you have fewer than 500 employees, you can get up to the lesser of $10 million, or 2.5 times your average payroll for the past year. The idea is to give employers the ability to get cash from the Small Business Administration, pass it through to employees, although it doesn't have to only be used for payroll. It can also be used to cover other qualified expenses such as rent, mortgage payments, and some other listed items. Certain debts can be paid. If you limit the items that you pay for to those qualified expenses, then the Act provides that loan can be later forgiven, and the loan forgiveness does not count as taxable income. So that's a pretty potent tool to be able to access cash and take care of the fundamentals of your business. Not related to the Act, but in effect now, because this is a declared national disaster and the state has also declared a state disaster, are SBA disaster assistance loans and grants. For small business, there's a grant of up to $10,000, and there are loans of up to $2 million. For for-profit businesses, those loans term out at a max of 30 years, depending on the term that you settle on with the SBA. And for-profit businesses get 3.75% interest rate. The nonprofit businesses get a 2.75% interest rate. There are also loans for medium-sized businesses, those with 500 to 10,000 employees. This is new with the CARE Act. It also doesn't come from the SBA, but rather from the Secretary of Treasury, we believe, through the FDIC. but there's not a lot of information out about this loan yet. This loan, the annual rate for this loan is capped at 2%, and the Secretary of Treasury can waive interest and principal payments for the first 6 months. I might add they may also do that for the payroll protection loans for smaller employers. The problem with these loans for medium-sized businesses is there are several conditions. Some of the more important are they have to be used to support, you have to certify that you need them to support operations during economic downturn. That the loan has to be used to retain 90% of your workforce or to restore 90% of your workforce as it was constituted on February 1st. You have to suspend the payment of benefits. There are some other provisions that apply only to public companies. And maybe the most insidious piece of this particular loan is that you have to agree not to abrogate a collective bargaining agreement. That's not too much of a problem for most Arizona companies because there aren't that many unionized companies. But you also have to agree to stay neutral in any union organizing effort. So that's a sort of a gotcha that non-unionized business would want to look at before engaging in those loans. Having said that, no one knows what those loans will be except that they're in the statute. So we're waiting for regulations, which are supposed to be here within the next 12 days or so. With respect to the way that the Congress has tried to get money to employers is with tax deferral and tax credits. And then they've brought back some deductions that used to be here and were removed by the Tax Cuts and Jobs Act of 2017. So there are opportunities to defer the payment of payroll taxes. And you already know, I'm sure that the tax payment deadlines and the tax filing deadlines for income taxes and for gift tax returns, by the way, has been extended to July 15th. And that's on the income tax side, that's both on the state and federal level. There have been separate pronouncements on both of those. Tax credits, employers can get a credit for 50% of the FICA tax that they pay, but you aren't eligible for that if you take a Payroll Protection Act loan or if your loan is forgiven under the payroll protection loans. So you have to balance these tools when you decide which way to go. And then, as we discussed last week, there are tax credits for employers providing paid sick leave and Family Medical Act leave under the Families First Virus Response Act. With respect to the tax benefits, that the deductions that have been restored, loss limitations on business losses have been removed, and net operating losses can now be carried back 5 years with respect to the 2018, 19, and 20 years. So that helps. You can amend returns, carry losses back, and seek a refund immediately. Also, corporate alt-min tax, when that ended, you might have received a credit, and that credit the receipt of that credit was delayed, I think, until 2021, and now that's been accelerated, so you can go get that money now. And finally, the limitations on deducting business interest have been increased from 30% of adjusted taxable income to 50%. Chris is going to talk about the leave. One thing I want to reemphasize, and this is from the Family First Act, is that health plans now have to provide testing and treatment for coronavirus without the usual copays and deductibles. But you need to check your plans. And as we talk through the scenarios of employees being off work for various reasons, keep in mind that when you're talking about furloughing employees, you need to watch your health plans and make sure you know and that the employees know when coverage would end if they're not actively at work, because each policy is different. So with that, I'll turn it to Chris to summarize what's going on in the leave areas.
Absolutely. Thank you so much, Otto, and thanks for updating us on that. I know I'm working with a lot of employers, as are you, and as is John. helping with a lot of those loans and loan issues. I know that's the key issue right now. Last week, we obviously talked quite a bit about the two different sub-acts within the Families First Act that applies to some of the leave that's going to be taken going forward. I'll talk a little bit about some of the FAQs. I won't go through all of this in detail. We did a circulated chart. I think everybody got a copy in their email today, sort of highlighting some of the key differences between the Emergency Paid Sick Leave Act and the FMLA Expansion Act. Hopefully that'll help quite a number of you with implementing different policies and evaluating some of the leave requests you're going to be getting going forward. The key point that I want to point out first and foremost is that those provisions go into effect tomorrow. We have to be ready to start complying beginning tomorrow morning, April 1st. You should have the notices posted at this point. You should be prepared to start fielding some of the leave requests that you may be getting. I'm also going to talk about some FAQs, some question and answers that have been put out over the internet by the Department of Labor. And while I'm talking, as a matter of fact, I just sent a copy of the link to the DOL's webpage for the FAQs through the Zoom group chat. So you should hopefully already know what that is or be able to link in through that link that I just sent out. I'm going to hit on some of the important FAQs that address some of the questions we had and provide additional highlights. I do encourage employers to go through those in detail. They'll really sort of solidify some of the requirements and help provide a little more detail beyond what I'll talk about here very briefly this morning. So first and foremost, and I'll talk about 10 of the different points, again, very briefly. First, we are getting a lot of questions from employers where there's a lot of interrelated companies. Perhaps they're all owned by the same owner or they're subsidiaries of each other. And this is important for purposes of the 500 employee cutoff. We know that these requirements apply to businesses that have 499 employees or less. The Q&A provisions within the Department of Labor's, on the Department of Labor's website indicates, and this is exactly what we thought, that when the companies are closely enough related, and there is a formal legal test, you obviously want to get legal advice on this, but there are situations where all those employees of those different entities are counted together, and there are some businesses, therefore, that would be exempt because they'll have more than 500, all those employees are counted. But again, you really need to get legal advice on that because the test and the established case law on that issue is very deep, and you want to make sure you're compliant with that. Secondly, retroactive application. Some employers started this leave early, and the DOL's webpage makes it clear that there's no retroactive application, that these rights begin April 1st, and you have to start counting on a going forward basis and providing the paid sick leave under both the Emergency Paid Sick Leave Act and the FMLA Expansion Act, so you need to be aware of that. It does provide a lot of added detail too. This is kind of the third point on teleworking. We recognized in these acts that if employees are able to continue working from home through a teleworking capacity, they're not going to qualify for leave. They're not going to be entitled to the paid provisions under these acts. And that's highlighted and detailed by the Department of Labor on that webpage as well. We encourage you to take a closer look at that for those workplaces, those employers that can have many of their employees telework. It is interesting on the intermittent leave question. This is the fourth point. The Department of Labor has indicated that intermittent leave for most of these scenarios is really going to be at the discretion of the employer. They've indicated in a lot of answers to some of these questions that it's at the employer's will if the employer is willing to work through intermittent leave arrangements. They are encouraging employers, of course, to be generous in authorizing intermittent leave. And we do encourage you, if you have difficult circumstances, again, there's some legal analyses that go into whether or not employees are entitled to intermittent leave depending on their particular health conditions, and you may want to look into that in more detail. And we do encourage employers as well to try to be generous where they are authorizing individuals to take some form of intermittent leave. And personally, where I've seen a lot of that come up is where you have two parents in different workplaces. One parent may stay home a few days and then go to work. The other parent may stay home a few days and then go to work to care for their children. And we do obviously encourage employers to try to be very generous in having that if they can. Another point that the Department of Labor confirmed is that for employees who've been furloughed or laid off, they're not going to be entitled to the paid leave. It's generally the principle we go back to. If you're not scheduled to work, you can't take a paid sick leave day for not being scheduled. Now, a lot of that, again, is going to turn on some of the nuanced questions where there are quarantine issues or decisions that employers are making on who to lay off or who to furlough. Obviously, you don't want to do so in a manner that interferes with the rights of workers to exercise their leave. You can't target employees who you're anticipating are going to go out on leave for furlough or termination. That could get employers into trouble. So you need to be aware of that. They clarified too that the son or daughter provision where employees are taking time off to care for their daughter whose school is closed or the child care is unavailable. Interestingly, in the FMLA it actually says a son or daughter who is 18 or older. But the Department of Labor has come back and said, no, we're going to apply our traditional criteria that indicates even if the child is 18 or older, if they have a disability and they can't care for themselves because of that, the parent can still take time away to care for that child. It is a little inconsistent with the actual statutory language, but nonetheless, that's the position the Department of Labor has taken on the issue. For individuals, interestingly enough, and we were anticipating this as well, who've already used some of their FMLA leave on the year for other reasons. There's a lot of other FMLA provisions that continue to remain in place for employers that have 50 or more employees. For those who've already used some or all of their FMLA, it will count against their ability to take paid FMLA leave expansion. So you should be aware of that. And make sure you're counting the days correctly. For employers that have calendar years or rolling years, you're going to continue to apply the same standard going forward. So you should be aware of that. Healthcare providers is defined very broadly. The next point that I wanted to hit on. Surprising to us too, we weren't expecting that we would see quite as extensive a definition of healthcare provider because it actually departs from the existing definition of healthcare provider under the prior FMLA and FMLA regulations. And we've advised employers to be cautious in holding that certain employees cannot take advantage of paid sick leave if they qualify as a healthcare provider. But the Department of Labor, at least in the FAQ sheet we're seeing on the Department of Labor website at this point, has taken a very expansive view of who qualifies as a healthcare provider. And that, again, is important in deciding whether or not those individuals are entitled to sick leave because healthcare providers aren't entitled to that benefit. Not saying that employers can't provide it, but they do have the right to decline it for individuals who are defined as healthcare providers. And then lastly, and this is something we were really looking forward to, and the Department of Labor has given us some guidance now on identifying what a small business would look like for the small business exemption. And to recap again, businesses that have fewer than 50 employees who qualify under the small business exemption are not required to provide paid leave to its employees if it meets the specific criteria. And that's now outlined in the answer to question number 58 on the Department of Labor website. And that applies for provision of the expansion, the FMLA Expansion Act. And it applies to one of the 6 leave reasons under the Emergency Paid Sick Leave Act, and specifically for those individuals who are taking time away to care for a son or daughter whose school is closed or childcare is unavailable. In those situations, the employer does not have to provide the paid sick leave, again, if it meets the criteria. It's small enough and the provision of the leave would meet one of the 3 criteria identified by the Department of Labor on its website. So be very familiar with that. And I do caution employers, if they're inclined to decline leave on the basis that they believe they qualify under that small business exemption, seek legal advice. Make sure you're absolutely correct about it because we don't want employers to find themselves in trouble or face some legal claim or action by the Department of Labor. So those are really some of the key points that we wanted to identify for your benefit. Again, take a close look at that. It will take some time to read through. There's a lot of information on the website at this point. And keep in mind, too, that some of this may change going forward. That's just the Department of Labor's initial response. we're still anticipating formal regulations at some point going forward. Those may change in some respect. It is, unfortunately, as Otto pointed out, a constantly moving ball, which is understandable given the emergency of everything going on. But definitely stay attuned to some of the changes as they come down. So with that, I do want to turn this over to my esteemed colleague, John Belitis, who I think is going to talk through or introduce some scenarios that we've been dealing with lately.
Yeah, hello again, everybody. We thought it would be helpful to share with you some, without naming names of clients, obviously, to share with you some real scenarios that we have been faced with over the past couple of weeks. And for probably all three of us, maybe multiple times, because we find that we are receiving questions from clients that are focusing on particular areas over and over again. And this will help bring some of what Otto discussed and Chris discussed probably into sort of a more realistic format for you, because you can actually see how clients are worrying and wondering about these various points, and then how we are helping them navigate through the law to reach conclusions. I'll start out with a couple, and a few of these pick up on some of the things that Chris was discussing. Like, for example, the issue of retroactive application of the leave provisions in the Families First Act. The biggest question that I encountered with clients relating to retroactivity was whether or not they could take the benefit of the act if they had been generous and had provided leave before the act became effective, which is tomorrow. Meaning, if they had paid out leave benefits to people before the act became effective, could they then offset that against their employer portion of withholding, like they will be after tomorrow, to help reimburse themselves for this expense? And the answer in the FAQ clearly is no, unfortunately. So if you are an employer that has been generous and has been providing benefits like this ahead of the effective date, you cannot take advantage of the credit or the offset in order to reimburse yourself for what you've spent. That was very clear, made clear under the FAQs.
John?
Yes.
John, can I ask you a question about that?
Sure. Mm-hmm.
So, but if an employer has done that, does that offset their liability that they would have no matter what under the Arizona sick paid laws?
Well, the Arizona sick paid laws, our Arizona paid sick leave law has been in place obviously for some time. We're looking at an effective date for Families First of tomorrow. So yeah, if I'm understanding your question correctly, Otto, any leave benefit that they've provided, paid sick leave benefit under Arizona law, is going to satisfy their obligations for, reducing accrued unused time that an employee may have in a bank for Arizona sick time. But I don't believe, given the way the FAQs read, that any amount of money that's been paid out by an employer prior to tomorrow can be used as a credit, either in leave time or dollars, against the obligations that come along with Families First. That's my understanding. One other question I've been getting a lot from employers also touches on a point that Chris discussed, which is the further guidance in the FAQs about small businesses and the exemption that applies to small businesses for purposes of the new leave components, and that is and this was prior to this weekend when the FAQs came out, how do I secure one of these exemptions? Because the way the Families First law read suggested that there was going to be a process that an employer would go through in order to obtain an exemption so that they could actually claim it. And now when you look at the FAQs, there is no process. What the FAQs say is that if a certain type of corporate officer within your company can make certain determinations, which you then internally document, you then just claim the exemption. There isn't a process that you have to go through to ask somebody for it in the federal government or secure it. You claim it. That, of course, can be tested later, presumably. But there isn't anything you need to do in order to start taking advantage of the exemption other than to be able to satisfy yourself internally that you can meet the criteria, and then you document it internally. And then you unilaterally take advantage of the exemption. There's no process for that. One more question that I'll address myself, and then I'll turn it over. I'll ask some questions of Otto and Chris. This expanded definition of healthcare provider that Chris talked about in the FAQs. He made a point to talk about the fact that this definition is much broader in the FAQ guidance than how a healthcare provider is defined in traditional FMLA regulations. And I had any number of clients a week or two ago, dental practices, home health care agencies, calling me and saying, will I qualify for the healthcare exemption, meaning can I unilaterally exempt my workers from these leave entitlements? And the advice at that time was no. A home health care provider wouldn't have qualified as under the traditional FMLA regulations. A dental hygienist probably wouldn't have qualified under the traditional FMLA regulations. Now, under the new FAQs, it appears to me that all those people do qualify. I'm calling clients back and saying, hey, incidentally, this wasn't anything anybody knew ahead of last Saturday, but the breadth of the definition of healthcare provider now has expanded. So your dental hygienist may be somebody who you can unilaterally exempt from the entitlements. Your home healthcare provider or your home healthcare aide that goes into homes to take care of people may very well satisfy the definition now. Whereas a week or two ago when we talked, it didn't look like they did. So maybe the motto of that story is to look very closely at the FAQs and the answers, because they are game changers in some respects, significantly. And Chris pointed out many of those. Otto, one thing I wanted to ask you, for my clients, probably the biggest development with the CARES Act financing relates to a point you made for loans that are now offered to businesses with 500 to 10,000 workers. And one of the big sleepers in the CARES Act, at least for me and many of my clients, was this concept that if you take out one of these loans, you then have to be neutral. You cannot challenge a union organizing effort in your workplace for the life of the loan while the loan exists, which, keep in mind, for those of you who are participating today, when employers start to reemerge out of this crisis, the best word I can use to describe them is vulnerable. It's going to be a process of reemerging to get their workforce reintegrated, their finances back in order, and you could make an argument that during that period of time, they would be most vulnerable to a union organizing effort. And while they're in this period of financing for the larger businesses that take out these loans, they can't contest an effort like that. They can't contest it. And so that is the biggest observation that I'm probably hearing from my clients on CARES Act material. How about you? Like what is one of the most common questions you're getting from clients about CARES Act financing and issues?
Well, I think the most common questions I'm seeing are which tools to use. You can go to the SBA website and they've got a special coronavirus section where you can see what kinds of financial assistance are available. And that assistance can go everywhere from a traditional SBA loan to the Payroll Protection Act loans. People, from a political perspective, what Congress did first is they passed Family Medical Leave Act and FMLA leave that was pretty narrowly focused. And then the follow-on with the CARES Act kind of opens, or is intended to open, the floodgates of money. So you can get a Payroll Protection Act loan that is completely forgivable, but cuts off some other alternatives. And so the big trick in the CARES Act is you've got to look at your tax situation, you got to look at your financial situation, and make a judgment about what works best for you. If as for most employers, a union organizing effort would be a big problem, then you might not want to consider that kind of loan. But there's half a dozen others. And I'll also add, as we've researched this, we've seen a variety of other alternatives for funding. There are nonprofit foundations providing grants. There are certain other government agencies providing grants, and those things have been in play for a long time. So
well, let me ask you something. You mentioned this, and I don't understand it because it's more in your wheelhouse. You just mentioned grants. There isn't. I thought in the CARES Act there is a provision for $10,000 discrete grants. Am I mistaken?
yes, that's true.
Well, but are those a grant though is different than a loan, right? In other words, if are these grants completely free of repayment obligations?
Yeah, the grants are. The grants are free of repayment obligation, and the loans essentially become grants, at least in the case of a payroll protection loan.
Right, but in terms of the grants, it's like it's a $10,000 grant, unlike the loans where you have to satisfy all these criteria in order to get forgiveness. The grant is kind of like, here's your grant, and that's it, right? Pretty much.
Correct. Yeah, that's exactly right. I think the idea is Congress understands that cash is the problem. I've been in conferences with several of the congressional delegations, and what the senators and representatives are saying is that this downturn economically is different than 2007, 2008. We've got plenty of liquidity. The problem is getting the liquidity to the street where it's needed. And so all of these different tools are an effort to get that liquidity pushed down to the employers and the employees where it's needed. And so it's really, the CARES Act provides a menu of opportunities, but you don't just go pick one thing or another. You really have to analyze your own situation and decide what works best for you.
Right. Well, and speaking of the menu of opportunities under the CARES Act, and I want to direct this question or observation to Chris, we are seeing some overlap between Families First and the CARES Act, because although there's a lot of business-related components to CARES Act about financing loans, disaster relief and so on, there are these elements that sort of cross over between business and employment. And, Otto practices more sort of in the employment/business area. Chris and I are more mainstream employment attorneys. One thing that I see in the CARES Act that is really exclusively employment related is the significant expansion of unemployment compensation to workers. So we have an additional, we all probably know that the maximum benefit for unemployment compensation benefits for a worker is somewhere in the $200 per week range, I think. Don't quote me on it. Under CARES, an additional $600 per week is now available for workers who have been displaced because of the virus. And they can actually, in some cases, claim that retroactively all the way back to the end of January, when sort of like the government sort of picks a date, January 27, where, we have to pick a date when this sort of all started to really, really ramp up. So the added benefits for workers under unemployment compensation is significant, dollar-wise. And then the period of time that the workers can take it is expanded an additional 13 weeks, from 26 weeks to 39 weeks. And so I see this aspect of CARES as a real overlap between a law that I kind of look at as being primarily designed to help businesses, where there are components to it still that really are focused on workers. And so Chris, have you, in your conversations with clients over the past week or two, as CARES Act, as we saw it sort of solidify, we sort of knew where it was going to end up in terms of its final version. Were you seeing questions from clients which either confused or overlapped CARES Act with the Families First, and how did you feel those questions?
Yeah, there's a lot of different, and it's a really good point and an astute observation, John, that there is a lot of overlap between the impact on the employees, the workforce, what employers are going to be entitled to. The big question that I've been fielding lately is what do we do as an employer if we have a workforce, we don't have the current cash to keep them working because we don't have any income, or we're not making any sales, nobody's coming through our door. How do we keep them working so we can get the loans that we need, the forgivable loans even? And it is a difficult question. And what I've been advising employers is you have to do an evaluation on a case-by-case basis, because what you do now as an employer, whether you decide to furlough employees, whether you decide to lay them off, is going to impact how much loan money you ultimately could get. And then if you're not able to reinstate those employees quickly enough, it's also going to affect how much of that loan is forgivable. And so I've advised employers, you've got to look at all of these criteria. Number one, you have to look at what your cash availability is, your particular financial situation, because the reality is it's going to take some time. I don't know how long it's going to take until these loans are evaluated, approved, and finally funded. And if you can't survive the next 2-3 weeks to get to that point, the rest of it's moot. So you have to make some emergency decisions right now, and that may be in your particular situation to temporarily furlough some employees. And I have a number of employers in that situation. That's their best course. Some employers conversely have more cash available, and they can survive in the interim, keeping people working, keeping them on their payrolls. One of the interesting additional offshoots, and John had mentioned this impact on unemployment, it's going to substantially increase the unemployment benefit. The cap, and John's absolutely right, the cap in Arizona has been $240 a week. That's the most somebody traditionally could get. You now add $600 to that, and you've got some employees who may, through unemployment, get as much as they would get if they were working. And so that's an impact too. If you furlough workers now, you lay them off, how hard is it going to be to try to get some of those people back in the workplace when they have ongoing fears of contracting coronavirus? If they're in contact with people, they're getting a financial benefit that pays them as much to be at home. How are you going to get things reignited to get everybody back working once you do get one of these loans? And a lot of these dilemmas that employers are going through, and I wish I had easy answers. It's really going to come down to what you can do as an employer, what's your likelihood of getting a loan. I think a lot of employers, small employers, are going to qualify. I have a little doubt of that, but I don't know when these are going to get funded. And it's really, again, it goes back to you have to make a case-by-case evaluation. And certainly we help talk through some of these issues, some of the practical sides, but this is the biggest dilemma that I've seen employers are facing right now.
Yeah.
Well, Chris, if I can put a little some dates to that, employers who have decided to furlough people for now and reduce their workforces wouldn't be entitled to, for example, paycheck protection loans and the forgiveness that comes with those, except that the Act provides that if you've done that since February 1st, or between February 1st and 30 days after the enactment of the CARES Act, which I think is April 26th, then if you bring them back by June 30th, then you're entitled to the loan forgiveness, and the fact that you furloughed them didn't matter. So that becomes pretty important because the statute provides the administrator with 60 days to consider a loan application. Now, this is a very fluid situation, and we think that the agencies are accelerating their procedures. In some cases, they're reaching out beyond what the statute says. So, for example, the Family First Act provided that employers' share of FICA would be available for the tax credits to offset paid sick leave and paid family medical act leave. The next day or two, the IRS blew right by that and said all payroll taxes, all income taxes withheld were available.
Right. Yeah, and this issue that we're talking about, which Chris really nailed, meaning how much cash a business on hand may drive whether or not they lay off or furlough workers, is I think one of the central questions that we have all been fielding, which is clients calling saying, should I lay them off, which means separate them, end the employment relationship, or should I furlough them, meaning keep them in the employment but just not have them doing anything, right? So many clients want us to try to answer this question for them. And really, a furlough is basically like a layoff, except A, you don't have to worry about all the administrative hassle and complexity of rehiring the workers then when they need to come back. And B, those workers typically will then continue to enjoy their employment-related benefits while they're furloughed, like their health insurance and so on, if the premiums are paid and whatnot. So furloughing, to me, if you're not paying the workers, if you decided just to furlough them and not pay, is probably the easiest and most logical solution generically. I mean, different businesses may have different situations which might drive a different result. One thing that I have been talking to clients about, which a lot of them don't know about, and help them answer this question about whether to lay off or furlough is the shared work program that the Department of Economic Security here in Arizona is offering. And if you get on the DES website, there's a link that you can click on that describes it. And what the shared work program allows you to do is, if you as an employer want to dramatically reduce the wages of a whole segment or your entire workforce down to something very minimal, these workers then remain employed and get that small wage, but then they can go to DES and file a claim and then make up the difference between what the small wage you are paying them and what they would have been making had they remained fully employed, up to the cap. And my clients that have become familiar with the program and have decided to use it have seen this as a vehicle, or as a maybe the tipping point to answer the question, should I lay off or furlough? Because they're keeping the connection with the worker's remaining in the employment, so he or she will be easier to recover and get back when we come out of the crisis, but the worker's still getting paid adequately, right? So if you want to take advantage of this program, you do, as an employer, you do have to file an application with DES. I don't think the purpose of the application is to approve or reject you. I think the purpose of it is so that they can have you in DES can have you in its system, so that when a worker comes in and says, my employer is participating in the work share program and this is how I want to file my claim, the DES person can look in their system and say, oh, you're right, your employer is participating and you can take advantage of this business. So of this program. So I would definitely check into that. The other point that relates to this is something that we all, Otto, Chris, me, and other members of our practice group were discussing online yesterday, and that is, if you take out a CARES Act loan, an element of which is to provide you as the business with the ability to meet payroll, do you have to have workers in active employment, meaning actually working hours, in order to then use that money to pay them? Because when the loan says you have to use the loan proceeds partially to maintain payroll, does that mean the workers have to be working, or could they be furloughed and not engaging in any work? And I thought this was a significant question. Maybe the answer to it is so obvious that it wasn't actually articulated in the act. Maybe it'll come in guidance later, but our conclusion was, yes, you can use the loan proceeds to pay workers who aren't actively working. And one of the reasons we reached this conclusion is the same reason that I talked about in connection with the shared work program, and that is these loans, part of the public policy behind this financing is to help employers maintain the connection with the worker so that when we emerge from the crisis, the worker can reintegrate into the workplace and with the employer as seamlessly and easily as possible, because we want businesses to be able to ramp up again efficiently. So Chris, Otto, did I summarize accurately what we ultimately concluded yesterday about the availability of these payroll funds through loans to pay what we could call inactive workers?
Yeah, John, I think you did. One question that we've seen, and I wonder what your thoughts are, is how does this apply differently to hourly workers versus salaried workers?
Well, you're right. I mean, if an hourly worker isn't working any hours, then there wouldn't be any payroll to pay that person, because if they are non-exempt, their wage depends on them working hours. A salaried worker, on the other hand, gets paid regardless of how many, their compensation is not tied to hours. So clearly this payroll relief would be available for exempt salaried workers. But Chris, Otto raises a good question. Like, what about a non-exempt hourly worker?
Well, if we're talking about the non-exempt hourly workers, if they're not working, they're not entitled to pay. I mean, that's really what it comes down to. If they've been put on furlough, if their hours have been reduced, whatever measures the employer has taken, they're only going to be entitled to the pay for the time that they're actually working. Now, I do agree with you. You've hit it absolutely correctly that once the employers get these loans and start getting to take advantage of the loan forgiveness program, it makes perfect sense to have employees stay on payroll. even if they're doing only minimal work, they're checking in weekly from home, whatever minimal work they may be doing, you can still pay them the full amount is our current rate. Now, again, a lot of this is subject to whatever changes we may see in the regulations. A lot of this, we're flying a little bit by what we see, what we know, what we evaluate currently. And as we've already seen from the Department of Labor, sometimes they take very different interpretations and expand or retract rights that we thought were pretty clear in the statutes. But I agree with you. I think that's definitely the way to go. One thing, too, with salaried employees that employers do need to keep in mind is if they're salaried exempt, you still have to make sure you are complying with the salary basis requirement to avoid running afoul of the FLSA. It's simply dropping them down or trying to pay them partial days may create major problems for the employer, and you need to make sure you're doing it right. We help a lot of employers walk through that process.
What's interesting about that observation that conceptually that Chris just made is that in many respects, these laws, CARES Act, Families First, you have to keep in mind that they don't automatically change other laws. You have to, the Fair Labor Standards Act, all of the requirements and everything you need to meet under that act, you need to keep meeting those and observing those. You don't get a, get out of jail free card if you do something wrong just because we've passed 2 big stimulus packages. On the other hand, these stimulus laws have driven changes in some of our other traditional compliance obligations. For example, and this is a little tangential, but if you all get on the EEOC website, eeoc.gov, you will see that the Commission has greatly relaxed the rules of the game under the ADA for dealing with workers in your workplace. Like, whereas historically, you couldn't ask certain questions of workers unless, it was job related and consistent with business necessity and all this. Now, you do have a lot of freedom, I think, in managing potentially, for example, an infected person in your workplace and policing it to get into areas of discussion yourself without having to worry about running afoul of the ADA. The same thing might be true of taking a worker's temperature. Under the ADA, that taking a temperature of an employee was historically thought of as a medical examination. And so that would require certain criteria be met before you could do that. I really doubt that in this situation we're in, that if you wanted to use that as a litmus test for people to enter the workplace, which probably wouldn't be that instructive, but let's say you did, I don't think you would really get a lot of grousing out of the Commission because of that. I'm hearing today that the CDC may shortly recommend that everybody start wearing face masks, which is extraordinary, to me. That in the workplace typically would have been governed probably by OSHA regulations and so on. Now, it's like, well, we're going to suspend that rule. And in other words, very fluid, very adaptive, because we're in a situation where that we've never experienced before. So with
John,
yes.
John, I might add that last week, the Department of Labor and the Department of Treasury issued a joint notice. And one of the things the Department of Labor announced in that notice was that there was a 30-day non-enforcement policy. So if they find that you're doing something wrong, for at least 30 days, they're going to try and help you figure out how to comply as opposed to coming down and chopping off heads. So that's very
excellent point. Excellent point.
I know that, we're hitting close to an hour. We do have some questions that I see are coming through on chat. So if those who have typed questions want to unmute and ask your question, now would be the time. I know we have a question from Alex Martinez. Alex, are you there still? I see that you're still logged on. Okay, I'll read his question. The SBA has 2 types of disaster loans available for small business, business loan and home or sole proprietor loan. Will a home-based business that employs remote workers that travel to customer sites, which loan is used?
Sally, I think the answer is, I don't know from his description exactly which loans he's talking about. There are, if you go to the SBA COVID-19 website, there are about 7 loans listed, different types of loans for just this circumstance, or at least that are being used for this circumstance. Each of those has different interest rates, different terms, different qualifications. So I think the important thing there is get with your SBA lender. Again, what John and Chris have emphasized is it's really important to look at your own individual financial circumstance with your lender and figure out what works best for you.
Okay, thank you. JR, are you on here?
Yeah.
I'm going to ask your question.
So what we did is took steps last week to reduce our employees to a 32-hour work week, just to reduce costs temporarily. I'm just wondering if that voids our ability to receive the payroll loan, because we're not paying full time. I mean, it's full time, but we just reduced them a little bit for costs. So what's your opinion on that? And should we just go back to 40 hours, I guess is what I'm saying.
Well, the way it works is you've got to look back at the statute. There's a formula for reducing the loan forgiveness if you reduce either compensation or your workforce too far. I think you can't reduce the workforce more than 25%, and I think you can't reduce the compensation more than a formula that relates back to a period of time that's measured last summer. So basically they're setting baselines for numbers of employees and compensation. And if you drop below those thresholds, you won't satisfy them. So I think it's important to check with the thresholds and make sure. Having said that, as long as you don't drop below those thresholds, if you reduce your compensation or you furlough some people and then you use the loans to supplement what you're able to do, I think that's acceptable. The forgiveness is based on using the loan proceeds to provide payment of the specified expenses, payroll being
okay.
one.
Very good, thank you.
Are you still on? You have a question?
Oh, yes, I'm still on, thanks. I had a question regarding the CARES payroll protection loan, and curious what the maximum amount of hours would be allowed during the 8-week forgiveness period, considering that we'll probably likely reduce on the front end and possibly even on the back end of the loan, depending on when business resumes.
I think the loans are premised on using your regular rates of pay and regularly scheduled hours. So again, for purposes of determining whether you're entitled to forgiveness, they're going to compare a baseline. I don't remember as we sit here what the dates are, but they're going to establish a baseline based on your pre-February 2020 performance, both in wages and in numbers of employees. And then if you fall below the benchmarks for those two numbers, then forgiveness isn't going to be available.
But is there a top, like, is there a ceiling to it potentially? Because once they give us the 2.5 times money based on, I think, the previous 12 months, I'm assuming that money's in the bank, and it's 8 weeks of pay, but they're giving us essentially 10 weeks of pay. So I'm assuming that difference in 2 weeks will be paid back unless we can use it towards rent or some other. So I'm sort of thinking, if we have that excess money, can we, an employee that, you know, my employees fluctuate in hours, the part-timers especially, and we're trying to meet the FTE requirements. So can we bump up those part-time employees so that we, one, satisfy the reduction component, even though they might be making a little bit more than they would normally?
You know, Simon, I'm not sure as we sit here, so I'll check it out and I'll call you later and we can talk about it.
Okay. I appreciate it.
I do know that there are some upper limits. For example, you can't consider salaries in excess of $100,000. So anything that supplements that would be non-forgivable. So I think there are some limits. Other than that one, I don't remember any off the top of my head, but I'll double check for you.
Hey, I appreciate it.
I wanted to add in between here is when we're talking about reducing hours or increasing hours or what we do, we've got a question here about, well, we just had it from JR about reducing hours. We need to, again, make sure that the health insurance benefits can continue if we reduce hours. Some of the health insurance well, most health insurance policies have a standard about what an employee has to be scheduled to work and how much they have to actually work. So really important to check those policies and make sure your benefits stay in place. Also remember for retirement plans, you may have benchmarks for hours of service, and so this could slow rates of contribution in some plans. Sorry, Sally.
That's okay. Brett and Sue have a question for you.
Yeah, I kind of want to piggyback off of Simon's question. So I know there's a limitation. You have to have 90% of your employees on the payroll to receive those loans. Do the hourly people and part-time people, do they count on that 90% or just the full-time people? We have 3 full-time people and 15 seasonal part-time employees.
My recollection is that most of the loans talk in terms of full-time equivalent employees. So it's kind of the same concept as the sick leave benefits and others and the Affordable Care Act, where you figure out of your total workforce, part-time and full-time, how many, if you combine part-timers, how many full-time employees you would have. But remember the 90, I'm going to check here, the 90% threshold is really for the medium-sized business loans. There are different thresholds, for example, for the paycheck protection loans. So it depends on which loan you're going for, and again, important to look at the details and your personal circumstances.
Thank you.
Anyone else have questions? When do you think that there will be enough changes that we can have round 3 of this?
I don't know, 2:30 this afternoon, maybe. One thing we should talk about, John and Chris, before we go is the governor's order, the one that says we all have to shelter in place on a golf course and don't get too close to the other golfers.
Yeah, we chatted about this morning before the call, and just to be diplomatic about it, it doesn't really, I mean, I got the order pretty quickly and read through it, and it doesn't really sound to me that it calls for activity that is much different than what we've been doing. If you work for an essential business, you can go to work. In fact, if you work for a non-essential business, you even can go into work as long as your non-essential business isn't open to the public. And so in terms of our daily in and out activity, I don't know that it really changes things materially. But what we did discuss, which is probably the most important point for purposes of this call, is whether or not the order could be construed as a quarantine order for purposes of triggering paid sick leave under the Families First Act. Because you may recall that criteria number 1 to receive 2 weeks of paid sick leave under the Families First Act is if you're quarantined by the government. And our collective consensus among me, Otto, and Chris was, we don't believe this rises to the level of a quarantine, and fundamentally for some of the reasons I just described. Chris, any disagreement there?
No, I'm in full agreement. I don't think that the recent order from the governor qualifies as a quarantine order.
Does that mean if there is a quarantine order, it won't be on a golf course?
Or at a nail salon or a hair salon, yeah.
Brett, do you have another question?
Sorry, I just wanted to know where a good resource is so we can get more of the information concerning the actual details of like the payroll protection package and those things.
Hang on, I'm going to send it to you. And figure out how to do this. Sally, how do I post something to the?
Well, that's a good question. Chris and I both figured out how to post it, but not actually have it be usable. If you want to send me something, I can certainly email it out to everybody.
Yeah, and one thing, if you're looking at the web page, Otto, you can go to the top and clip that web page address and then put it in the text box in the Zoom group chat. And
So I just did that. You'll see at the bottom, that's the SBA line to the COVID response loan guidance. There are
you may have to hit return, Otto.
Yeah, I don't
again?
see. I don't.
Hit return.
I did.
Okay. It just
Try and paste it again, Otto.
Oh, I sent it to Rosa apparently.
oh yeah, you have to.
Rosa.
Yeah, you have to click everybody.
I don't know how to. Oh, I see. Sorry.
Yeah.
Folks, it's just a miracle that we're actually on this call and that it worked.
It is for me.
Yeah, well, we're paid to be lawyers, not technicians.
I'll add, Brett, that we have a whole page dedicated to COVID information, and it's everything from federal to employee stuff and messages about individual businesses that have sent us stuff. So you could look at that page. It's probably on there too.
Okay, thank you.
I'm going to cut and paste right now for everybody from what Otto sent. Nope, never mind, I didn't. I apologize. I thought.
That's okay. Otto's got it on there. Any other questions? We'll keep tabs on this, and when Chris and Otto and John feel that there's more information to be shared, we'll set up another Zoom.
Thank you, Sally.
No,
Thanks, Sally. Thanks, everybody.
Thanks,
appreciate the
everybody.
information.
Thanks, everybody.
Stay safe.
Thank you.
Thank you. Have a good day, everyone.
Thank you, everybody.
Otto, I sent you Simon's information for you to call him.
All right. Thanks, Sally.
Thank you. Goodbye, Mr. Lawson.
And John, can you call me, please?
I think John's already left, Rosa.
You got
Otto, do you have John's contact information that we can get for Rosa? Otto?
I'm sorry, what?
Do you have John's contact information that you can get for Rosa?
John Belitis?
He already jumped off the call.
Oops, wrong keyboard.
Yeah,
I can run NASA
run
from
that.
here.
We will be sending out a Zoom link for a call with the U.S. Chamber to talk about grants. I think it's for Thursday, so watch for that. I think that might be something that you'd be interested in, Brett.
Yeah, that sounds good. That's Sally. Thank you very much.
Thank you. Do you
Chris,
see
take a
Rosa?
look. Take a look at those emails. Did I get them right?
Rosa, you see the emails in the chat?
I'm looking at them.
They look correct. You got it.
Good.
I don't
Excellent.
see John's contact.
Technological.
John's email is right there, Rosa.
Let's see.
It's J Belitis at JSS Law.
Thank you so much. I got
You
it.
guys,
Thank you.
have a good day.
Thanks,
Thank
guys.
you, everybody.
Thank
See
you.
ya.